Hi, my name is Gus Hossain, and I'm the Executive Director of Privacy International. Today, I'm fortunate to be here with my colleague Caroline Wilson-Palo, who's a legal director at PI, and with Edward Snowden. We're very grateful he could join us today. As you all know, of the great feats that Edward Snowden has done, since then he's also become one of the great communicators on issues around surveillance. And so what we thought we would do this time, rather than have Ed do all the talking about all of his deep perspectives on government surveillance across the world, we thought we could turn it around and give Ed a chance to ask us some questions, particularly in light of the European Court of Human Rights judgment that's on its way that will be ruling on many of the issues that he raised in his own work. So without further ado, I'm going to pass on to Ed.
Well, first off, thanks for having me with you. I got to say, I've been following Privacy International's work for a long time, and I think what you guys do is essential because particularly when we start to look at even, advanced democracies in EU or recently EU countries, there have been, there's kind of a presumption, I think, that governance is of a high enough quality that you can just trust the government, that things will work out, that it's all okay. And I think people really miss largely the reality, which is that governments don't reform themselves. Power never limits their own capability without a demand, without some kind of force or pressure, or in our case here, a court judgment that says, look, you've gone beyond the lines. Your crayon is way outside of what it should be doing. And this is something that I'd like to hear a little bit more about, which is this case before the European Court of Human Rights. What exactly is it? What is the case? Who are you challenging? And what's in contention here? Why should we care?
Well, fundamentally, this case is challenging two practices of the UK intelligence agencies. The first has to do with their mass interception of communications. So this is all the content and the metadata that's traveling over these massive connections, fiber optic cables that connect all the countries of the world, really, but it just so happens that all of them happen to run through the UK. And it turned out, thanks to your disclosures, we learned that the UK government, the intelligence agencies had been slurping up almost all of those communications for their purposes of their intelligence work. So we first challenged the legality of that practice, but then the second aspect of the case is the fact that the US, turns out, does very similar things and was sharing all of that data with the UK. And we also thought that there was absolutely nothing written in the law around the fact that this sharing was happening and how it was being controlled, so we wanted to challenge that too. So ultimately, that's how this case started out, and it's really important because both of these forms of surveillance can be incredibly chilling to our participation in our democracies and ultimately to the right to privacy, which is what we defend. But maybe Gus can talk a little bit about how we got started with this case, because this was a case challenging a law that had actually been on the books in the UK since 2000, but we hadn't taken the case up until that point. And yeah, you can talk a little bit about
Yeah, so in your own storytelling, you recount how the US law back in 2008 had some vagaries in it that allowed what essentially became upstream collection. The UK law had some really odd things in it as well. And an old colleague of ours, Casper Bowden, he identified that both these laws had these problematic clauses in it, and he was keen for us to take legal action, saying there's something wrong here. But at the time, we had two problems. First, we had, at least in the UK, we had the police who eagerly wanted access to these powers. And so time and again, the government would reintroduce policies to allow the police to get access to bulk data. And we had to keep on pushing back. And occasionally we thought we won, when in reality, we weren't paying attention to what GCHQ, or the UK Intelligence Agency, was doing, which was they were already at this game. So it wasn't until you came forward and provided us with the evidence we needed that we could actually take a step on this.
Ultimately, when it came to the intelligence services, at least what Gus alluded to, is that there's a certain amount of shooting in the dark. because they obviously operate in secret. And I think a lot of people, except for maybe Casper Bowden and a few others at the time, didn't actually anticipate that they were gathering all of this information. So we didn't think that we needed to bring a lawsuit to stop a practice that we didn't really know was happening. But you make a good point as well that the law in Europe is a little bit different from the law in the United States, in that not only is there GDPR, but under the human rights framework and the main provision that we use to take this case, which is Article 8 of the European Convention on Human Rights, when data is gathered, and it doesn't matter by whom, it can include the intelligence agencies, it has to be for both in accordance with law, the gathering, and necessary and proportionate. And it's that latter aspect in particular, that the data being collected is for a necessary purpose and the collection is proportionate, that actually, if enforced correctly, can help us take control over that data. And that's a lot of what we've tried to do in this case, and a lot of what we see as we've gone through the case, subsequent courts, especially the European Court of Human Rights, starting to do, which is saying that this data actually can't be passed around to anyone for any purpose. It has to be kept for limited periods of time. They've not gone far enough in that regard. We'd like them to go further, and that's why we're awaiting this latest judgment from the Grand Chamber. But it helps us take back a little bit of that control. But that being said, that's also why this case is somewhat unique, because we actually had your disclosures to understand a bit about what data was being taken for how long it was being held, so we could litigate around those issues of storage, of what selectors were being used. And this is actually a really crucial aspect of the current judgment that we're appealing, that the selectors need to be approved by independent authorities, hopefully a judge, in our view. And so that all this data can't be abused, and it'll be used for a very specific purpose. And that we couldn't have gotten into those details, and many other cases around the world haven't been able to get into those details because they're dealing with high-level bare powers enshrined in law, if they can take the case at all in the first place.
This is a fundamentally dangerous thing for democracy, because there's this idea that democracy is participatory, right? So if we don't know what's going on, we merely suspect what's going on, we can't really respond to anything. We can't marshal our processes, our resources, our opposition to a policy, because they can simply say, well, we neither confirm nor deny that this thing is happening at all. But isn't it true that the immune system of democracy is based on facts? And in the moment that we have today, that's very much in jeopardy. That distance between what we suspect, what we believe to be happening, and what we can prove to be happening is, I think, intentionally being obfuscated. And how does that dump cases out of the courts? You know, how did you get to bring this case in a place where there's an Official Secrets Act? I would say sort of a general allergy amongst government officials to letting the public have any say at all in what they can and can't do.
What we've learned through the course of this case is that it really does take an adversarial process to help make that happen, which I think everyone has acknowledged. The UK is somewhat unique, different from the US and some other jurisdictions, and that it has this, and you've already mentioned it, the Investigatory Powers Tribunal. And this is part of the reason we were able to take this case in the first place, which we did with Amnesty International, Liberty here, the ACLU, and a variety of other organizations from around the world that defend rights. But we took this case to the IPT because the IPT, unusually for a court or tribunal, actually doesn't require a claimant coming to them to prove that they were under surveillance. This is usually one of the big problems with taking surveillance cases around the world, is that in order to get into court, in order to show you have this concept of standing, you have to say that yes, I was actually surveilled, I was harmed somehow. But the IPT, especially at the time we initiated this case in 2013, was set up specifically so if someone suspected they were under surveillance but had no real proof of it, as you usually won't because it's happening in secret, could walk in and bring a claim and say, I think I'm under surveillance, I need you, IPT, which is both a court but also has investigatory powers itself, to investigate and tell me whether or not I'm under surveillance. And this actually worked really well for us in this case. We didn't have a standing hurdle. We were able to go right in and say, we now think that this mass interception is happening. we think this intelligence sharing is happening, although the intelligence sharing was a little bit easier because, in fact, the US government had admitted the intelligence sharing was happening. so the court and the UK government had to accept that that was indeed an activity that was taking place. But the UK government actually responded to our initial claim by saying neither confirm nor deny. We can't tell you if we're actually collecting all of this data. But that didn't stop our case, because the IPT was able to proceed on hypothetical facts. So we essentially said to the court, if hypothetically a program like Tempora existed, would it be lawful? Would the law in place right now make it a legitimate intrusion onto privacy? And that actually was a pretty funny aspect of the case, in that at one point we had a debate in court as to how to pronounce Tempora, because the government would neither confirm nor deny the name of the program, even to the extent that they wouldn't pronounce it for the court. So the judges were asking, well, how do we say this? Do we say it as tempora, or do we say it as tempura? So is it fried Japanese food, or is it time, something to refer to time or a time machine? And everyone in court pretty much agreed that it was probably time that we were talking about.
Tell me more about the general case. Who are you representing, these non-governmental organizations, and what are they calling for? What's in controversy here, and what are you hoping to win? And not just what are you hoping to win under the law, what can the courts provide, what can the process provide, but what do we really need? What's being sought here? And how do you think the government's likely to respond when they realize, which they certainly already have, what's at stake for them?
So we are actually one of the parties to the case. We have separate counsel, and we took the case with 10 other human rights organizations. So I mentioned Amnesty International, Liberty, which is a civil liberties organization here in the UK, but then a number of, because at the time this was seen as such an important issue around the world, a number of other organizations from all around the world joined the case too. The ACLU in the US, Legal Resources Center from South Africa, Bytes For All out of Pakistan. So it really was an international effort to bring the case. And fundamentally, what we were trying to do was stop mass surveillance. And we haven't gotten there, unfortunately. That's been a real uphill battle.
It's not just you.
Yeah, exactly. That's been a real uphill battle. But fundamentally, that's what we were trying to do. To get a little bit more into the weeds of that, I mentioned Article 8 earlier. This is the right to privacy under European law. And that sort of has two components into it. One says that if you're going to violate privacy, which is a qualified right, states can intrude upon it at times, but it has to, those intrusions have to be both in accordance with law and necessary and proportionate. And the in accordance with law part means essentially that you have to know that there's an intrusion that's going to take place. There has to be some law on the books that makes it relatively foreseeable. Not necessarily that you are going to be spied upon, but that someone, that this type of surveillance can take place. That there have to then be safeguards in place, recognizing that surveillance takes place in secret. So you need those really important oversight and safeguards and mechanisms to make sure it's not abused. And then finally, you have to ask the question is, even though you have this power, is it really necessary and proportionate to use this power? And fundamentally, that's where we come down strong on the side of saying mass surveillance. This type of bulk interception that the UK is engaging in isn't necessary or proportionate. For hundreds of years, we've tried to strike a balance around surveillance and say, yes, there are some people we need to investigate, criminals, so on, and for that reason, if you can articulate reasonable suspicion, some reasons why those people might be doing something wrong, you can investigate them. But it's unacceptable to put everyone under surveillance, because once you've done that, you've essentially shifted the power so much from the individual to the state that it makes it much harder for the individuals to freely engage in democratic society.
But I have to say, it's even shocking that, because Caroline said there's two tests. The first is there a law? And second, is it necessary and proportionate? But even on the question of, is there a law? Yeah. There's been some amusing moments where even when the government is forced to admit that, it's not quite a law, we'll figure it out. What was their response? Yeah,
so with regard to intelligence sharing, there was no law in the books, there was nothing, so they were clearly going to lose that first prong in accordance with law. And so most of the way through the case, they produced a 2-page document. It wasn't titled, it wasn't clear what this was. It was just sort of a untitled two-page document setting out what they said had been, of course, their policy all along with regard to how they treated data that was shared from the US to the UK and then used by the UK intelligence agencies. And ultimately, this is where it can be problematic, litigating, especially at the UK level at the IPT. The IPT said, okay, that's good enough. Now that you've given us this two-page document that's not a law, there's no sanction of Parliament or anything else around it, that means that people now know that if data is shared with the UK, this is how it's going to be treated, and that's sufficient. So you're right that we actually won at the IPT level on everything that had happened before that two-page document was produced. All the intelligence sharing was held to be unlawful, but going forward, they said that two-page document was sufficient, and we're still having to fight that battle because, we say it's certainly not.
This is not conduct becoming of a very old democracy.
In the context of all of these challenges, all of these problems, and this particular case, what progress can be won from this? What is the reach? Who does it affect? And how does it help? And where can we draw hope from when so many people are feeling disenfranchised and disempowered that even if the process doesn't work right now, we can make it better. And eventually it will work because we made it work.
We have had some wins in trying to put in place, and admittedly these are incremental changes, but trying to put in place better systems to help those people do the right thing and to make sure that they're reminding them to do the right thing, which is, as I mentioned earlier, that there's better oversight, that there's going to be independent authorization for a lot of the choices that are made as to who will be spied upon, which is a big change for the UK. That was actually a huge change, not only in the course of our litigation, but in the Investigatory Powers Act as well. That was a new, judicial authorization was something the UK never had before, and now it has, which was actually a significant safeguard and movement forward. We also are seeing a recognition that content, for a long time they used to say content was the most important, what you wrote in your email was the most important information and therefore needed higher safeguards. Now the courts recognize that the metadata, everything about the who, what, when, where you're talking can be equally intrusive and powerful, and so there'll be safeguards around that. So we're making these little steps forward, and I think maybe to illustrate that the best as to how that's actually can sort of change the tables a little bit, move the goalposts for the intelligence agencies and the governments that are arguing against this. In a separate case that came out of a different one of our lawsuits, I was recently in Luxembourg, where the Court of Justice of the European Union sits, where we were standing up against 20-some-odd countries that were arguing against us, because the way this court works is that every country in the EU that wants to come and argue, they get to come and say something to the court. And we, our counsel, were arguing for our position, and all of those other countries, because we had won a previous court judgment around these issues like independent authorization and not having indiscriminate retention of data, they suddenly had to argue they had to take our arguments seriously and convince the court to roll back what it had said previously. But no longer were we on the back foot. They were actually having to argue as to why they needed indiscriminate retention, and those arguments weren't always necessarily that strong or that powerful. So sometimes we can flip the script a little bit, and we do have those little victories that continue to move us forward.
Well, that's exactly the thing that gives me hope. It's that fact that, we don't have to win in all cases, but we do have limited shots. And when we do win, they count. To get back to specifics, what is, in this case, what does it mean for surveillance generally if you win and if you lose? And what does it mean for Europe?
So ultimately, our ultimate goal would to have the court say that mass surveillance is unacceptable. We realize that is while we're reaching for that, that may not be fully realistic. We'll see what the court says. But at the very least, I think we're going to enshrine even further in law these important safeguards of independent authorization. Potentially, we'll get notifications so more and more people understand when they are under surveillance, which when you're dealing with mass surveillance, that's a whole lot of people who maybe then will be brought into the conversation because they're worried when they see that they are actually being surveilled. In fact, maybe they do have something to fear. And hopefully then again that equivalence between content and metadata will also be preserved. And all those are really resetting for 500 million people across the countries that are part of the convention, the rules for how intelligence agencies have to operate. And as we've been saying, then there's going to be a whole new fight of enforcing those rules, but at least we've got another powerful tool in our belt if we win.